slideshow. Okay, so tonight's webinar, we are going to, by the end of this webinar, you'll learn how to complete your estate plan with confidence without hiring an attorney, even if you're new to estate planning, even if you're short on time, even if you're not the DIY type, even if you can't stand legal jargon, and even if you think it's too complicated. Okay, so that's a tall order, and we'll have to cover a lot of material to get you past these concerns. So it's the webinar. We're going to start with the 3 threats to your estate, because you want to know to make sure that your living trust will be able to counter those threats. Then we'll go into 4 steps on how to create your living trust. I also included this next item because I want to be upfront that one of my goals is also to partner with you to get you to the finish line at a fraction of what an estate plan attorney costs. And I'll make sure we have time for Q&A. Okay? Great. You should be able to see a full screen of the slide right now with my head at the bottom left corner. If you have any problem, send a chat. So I'm Mirtha Chang. I am a certified estate planner and author of the Estate Planning Decoded book. I also run a YouTube channel that breaks down estate planning concepts. Many of you probably found me through my YouTube videos. So tonight, if nothing else, I get to prove to you that I'm a real life person, not an AI talking head. So what's missing from About Mirtha? You don't see a law degree because I am not an attorney, which means I'm not charging you, billing you by the hour, which also means I'm not limited to one state. All my clients are from all 50 states, and I also will not be drafting legal documents. I partner with wealth.com. It's a top-notch online estate planning platform that's backed up by Google Ventures, Schwab Ventures, Citi Ventures, and used by thousands of financial advisors and estate planning advisors in the US. Okay? Great. So today's agenda, we're starting with 3 threats to your estate, because when you start on any project, it's important to understand the why we're doing this. And why you're creating a living trust is to protect you against these 3 threats. If you don't have an estate plan, then the courts take over. That process is called probate, and it's gotten a bad reputation, but actually its intention is to protect you. The courts are trying to honor your wishes. If you have a will, the court wants to make sure, is this yours? You created it out of your own free will? Or were you pressured? Was it altered? Or God forbid, is it a fraud? The court's job is to make sure that your will is authentic. If you have minor children, it will make sure that they now have a guardian in your place. It even goes as far to oversee that your estate goes to the right heirs, because you're no longer around to oversee it. If you remember when you buy your house, when you sell your house, it's a big deal in the US to transfer a title from one person to another person. You have lawyers, brokers, buyer sellers, everyone's like signing off gazillion, documents to make sure that the title is transferred to the right heirs. Well, when we pass away, we're no longer around. So if you have assets still in your name, someone needs to make sure that it's going to the right heirs. That's why, by the way, a will is insufficient. We'll go into that later, because with a will, your assets are still in your name. So the courts are trying to protect you, but how it plays out oftentimes is a nightmare. Here's a heartbreaking story of Jane Mansfield. She's a successful actress who died in a car accident without an estate plan. And her four children had different fathers, so the courts split them up to be with their respective fathers. Even though many of her friends said that Jane would have wanted her mother to raise her four children together. But when you don't have an estate plan, the court does its own plan. Her assets were frozen, so the children were denied access into their own homes. Even small things were locked down. Her daughter wanted this charm bracelet, sentimental value, and she was denied, and the bracelet was ultimately sold by the estate for nothing. It took 10 years for her probate to wrap up, and by the end, 90% of her wealth went to probate attorneys so that her kids ended up with nothing. And this is not just a story for celebrities. This recent Forbes article talks about mainstream families, how they underestimate the probate. It is emotionally draining. It takes, on average, 20 months, almost 2 years. And all that time, your estate is frozen. You don't have access to it. And it's also expensive. The data shows that it costs on average 3 to 7%. So if your estate is, let's say, a nice round number, $1 million, and your probate went smoothly, no family drama, no surprises, so it costs the lower end of the estimate 3%. 3% of $1 million is $30,000. That's money that should go to your spouse's retirement or to your grandchild's college, fund, not to the courts. So that is threat number one, the agonizing delays, stress, and costs of probate. The second threat is a more direct assault to your estate. Okay, Uncle Sam, our wonderful federal IRS tax organization. You know, Uncle Sam is not your real uncle, right? He doesn't send you a birthday gift. He doesn't help you move. He doesn't send you a housewarming gift. And yet, at every stage in your life, he's there, hand out to collect his share. Your first job, he shows up for a share of your wages. If you ever won a lottery, $20, well, $20 you can probably get by. But any big lottery winnings, he's also there. And if you pick the right stock and you made money on your stock, guess what? Uncle Sam wants his share. And when we pass away, he doesn't slack off. Not one tax, three different taxes. First, you have your estate tax. That's the tax that is paid by the person who died. And of course, he's not around to write a check, so it's taken out of his estate before it even goes to his heirs. There are two levels, the federal estate tax and the state estate tax. Now, fortunately, the federal estate tax, even though it's very high, 40%, has a high exemption, which means if your estate is less than $15 million, that's the exemption for this year. If it's less than $15 million, you don't need to worry about the federal estate tax. But if you're unlucky enough to live in one of the 13 states with a state level estate tax, then you are still, exposed. In my state, Massachusetts, the exemption is only $2 million. So anything above $2 million, I will have to pay a state estate tax. The next tax is the inheritance tax. That's the tax paid by the person inheriting the estate. Okay. Fortunately, there's no federal inheritance tax, 0%, and very, very few states still have an inheritance tax. And if you're a child of the deceased person, oftentimes the inheritance tax is waived. But if you are a niece, a nephew, or a lucky neighbor who's getting an inheritance, then it's not waived. So you want to check with your particular state. Now, you may be surprised that I put this third tax in, which is your IRA, retirement fund withdrawal tax. It's because working with many clients, I realize that for most people, their estate is their house and their retirement fund. And when they see the balance of their retirement fund, they think that's the value of the estate, not realizing that Uncle Sam has been your silent partner all along. Every dollar you're going to withdraw from your retirement fund, Uncle Sam's going to get a big cut of it, depending on your income level. It can go all the way up to 37%. And what is what is so concerning to me about this partner is that he has the ability to decide how much of a cut he gets because he can raise the tax rates, he can lower the tax rates, he can change the tax brackets. He decides what that is, and that determines his cut. Have you ever worked with a business partner like that? Well, that's Uncle Sam for you. So you want to do some tax planning to make sure that your estate doesn't, all end up there. So say you dodge probate, you even manage to dodge Uncle Sam. Now your estate safely makes it to your heirs, your children. Guess what? A new set of risks show up. Dangers to our heirs' inheritance. Have you heard of the lottery winner's curse? Many lottery winners lose their winnings in a couple of years, and some of them are even worse off. Too much money, too quickly, without guardrails. That's what happens. And that could happen to your children if you don't plan properly, if we don't prepare them, if we don't educate them. That is a big risk. Or some children feel so responsible about their inheritance, they feel a pressure to grow it. So they get into high risk scams, high risk ventures that they know nothing about and end up getting scammed or losing their inheritance. Are your children in high risk professions like a surgeon, attorneys? Then, lawsuits and professional liability could put their inheritance at risk. Potential divorce, that's a big one. Inheritance is normally considered separate property, but over the married life, it's so easy to get it commingled. Let me tell you about my friend who made a donation. He took a small part of his inheritance to donate to a charity he really cared about, and he added his wife's name to the donation. Nice guy, right? Well, a few years later, when they divorced, the wife's attorney claimed that that one act alone made that inheritance a marital property. So half of it walked out with his ex-spouse. It's serious, even though it made me think of this half, funny phrase that said, no good deed shall go unpunished. Anyway, moving on. Or what about heirs passing away? Like your entire estate went to your child, and God forbid he passes away before he creates his own estate plan. Then the law says all his estate goes to the next of kin, which would be his wife. And if his wife remarries, then that entire inheritance could leave the bloodline. So these are the dangers to our heirs' inheritance that we don't normally think about. And it also explains the data. This data of 3,200 mainstream families shows that by the Second generation, only 30% of that estate is left. And by the time it gets to your grandchildren, the third generation, it's just crumbs. This does not have to be your story. You hear about smart families like the Waltons, smart, wealthy families. Not only are they able to maintain their wealth, it can even grow over generations. Now, you don't hear about that a lot because in the past, that is reserved for ultra wealthy families, because to set up structures and sophisticated strategies like that costs ultra, high attorney fees. But today it's different. They're powerful estate planning platforms that gives you this kind of flexibility, not with, as much sophistication, but you don't really need that much sophistication unless you have, 50, $100 million. But today's platforms are so powerful that you can set up strategies because you want your inheritance not to end up like the left side, this orange bars, but more like the blue bars, right? So that is threat number two, wealth erosion from external and internal forces. Let's talk about the third biggest threat, because it's not financial, but it's even, I feel, more, to me, even worse. It can be summarized by this guy's quote: "You don't know a man until you've shared an inheritance with him. Even if you think you know your brother well, you may not know his wife or his grown children." I'm referring to the third threat, which is family fracture. What does that look like? You've seen it. But let me just list a few things. Siblings stop speaking permanently. A surviving spouse and stepchildren become adversaries. Family gatherings, the Thanksgiving table, you don't have 20 people anymore. It's now 8 people. Traditions die. And instead of having conversations, you're having fights in courts with your respective attorneys. That's really sad. So, those are the 3 threats that I want to make sure you're aware of as you embark on this journey to create your estate plan. How does a living trust protect you from those 3 threats? That's where we are now in the agenda. So first, let's summarize again. A good, well-designed trust has to protect you against probate, preserve your children's inheritance. You don't want the chocolate cake that you've worked your whole life for to end up in crumbs too quickly. And you want to keep your family whole. So what a living trust allows you to do is to transfer your assets into the trust. You are no longer the owner of those assets. You are a trustee. But don't worry, because just because your name is not on the title of your house doesn't mean you've lost control. As the primary trustee, you can still live in the house. You can decide to take the house out of the trust because it's a revocable living trust. It means you can make these changes. You can take your house out of the trust and sell it. You can buy another house and put it back in the trust. You even do all your tax reporting, pay your estate taxes with the same social security number. Nothing changes day to day, but what you've done is to have your assets be titled in the trust so that if you pass away, your assets are not still in your name. Because if your assets are still in your name and you're no longer alive to sign off on the transfer, that's when the court step in. This is why actually a will is not enough. With a will, you can specify your wishes, but your assets are still titled under your name, and you're not around to sign off the title. So a will is a ticket to probate. You need a trust. How does a trust protect your children's inheritance? With a trust, you can stagger your children's inheritance. Depending on the maturity level of your children, you can have a quarter of the estate be distributed at age 30 and then the rest at age 35. It just allows them time to mature, Before they reach that age, it doesn't mean that they cannot get help from the trust if it's needed. The IRS, in the US, the IRS recognize HEMS. You'll see this phrase a lot. It stands for Health, Education, Maintenance, and Support. What this means is that even if your child has not reached that milestone age, if he ever has a need around health, education, maintenance, or support, the trustee can distribute funds to the child. Okay? So this is like the best of both worlds. His basic needs are covered, but the inheritance is protected from mismanagement, from creditors, from lawsuits, because no one can sue you for something that you don't own yet. So a trust allows you to stagger your inheritance. In my situation, the age for me is to distribute the assets to my children is never, because I want those assets to be protected their entire life. If they ever need the funds for their basic needs, health, education, maintenance, and support, which I feel covers a lot, the trustee can still distribute funds to them, but their entire life, because I have a son who runs his own business, I have a daughter who is in an occupation that also can get sued often. So this way, their assets are protected their whole life. How does a trust protect you from a family fracture? Nothing is 100%, okay? If you have heirs that are bent on fighting it out, that will happen. But a trust can minimize that risk, first of all, by avoiding probate. Probate has a way of turning loving, harmonious families into strangers, into strangers who are suspicious with each other. One thing, probate is public. So your assets will all be listed publicly. If anyone goes to court, they can see everything you left behind. It's as if you list them up all on Zillow. Your cousin, your relatives, your nephews, your nieces, everyone can decide if you were really fair or not. So just by that public nature, also probate freezes your assets. You're having to cover funeral costs, memorial services without help from the estate. Things like that could just stress and break a family. Another way, just by the process of creating a trust, I feel parents are forced to think and process, family dynamics, what's fair, what's expected. So there's just a lot more thought given, because families usually don't fight about money. They fight about confusion. No, this is what dad meant. No way, this is what dad told me when he was alive. It's confusion that usually creates this family fracture and surprises. So a trust can help you prevent that. All right, now we are going into the next section, 4 steps to creating a living trust. I've gone really fast, covered a lot of material. You guys doing good over there? For some of you, this may feel like estate planning 102. Well, we are entering estate planning 102. So Buckle up, put on your seatbelt. We have more to cover. 4 steps to creating a living trust. For a lot of people, the thought of creating their estate plan is overwhelming, but they're really just 4 steps. Think of it like you're building a house, okay? First step, you're making key decisions before you even hammer a single nail into this house you're building. Do you want a 2-bedroom, 3 bedrooms, bathrooms? Do you want the master suite on the ground floor? That kind of thing. You want to just think through before you even start the project. The next step is to find a team, an experienced team that can build this house well for you. The third step is to make sure your house gets inspected, approved before you move in, which is the 4th step, moving in. You're going to think like, Martha, duh, of course, you build a house so you can move into the house. But you know what? So many people spend the money, time, and effort to create a living trust, and then they don't move their assets into the trust. Sad. All right, let's drill down into each of these steps. What does key decisions mean for, when you want to do an estate plan? What are the kinds of things you have to think about? Let me just give you a few examples, okay? For a married couple, when the first spouse dies, do you want everything to go to the surviving spouse? Or do you want the assets to be split up so you end up with 2 portions? The part belonging to the deceased spouse and the part belonging to the surviving spouse. Because when you split it up this way, which I see more often with blended families, then the trust belonging to the deceased spouse can be protected for his children. Because in the first case, if everything goes to the surviving spouse could remarry, the surviving spouse could even rewrite the entire trust and disinherit her stepchildren. Okay, so I see this more with blended families, second marriages of older couples, where then the deceased spouse wants his share to be protected for his children. So these are heavy things to ponder about. If you have children, for sure you want to be thinking about when your children will be ready to get their inheritance. But not just that. Until they reach those milestone age, would you give them management powers? Would you give them the trustee cap so they can be trustee of their own descendant trust? The advantage is that they don't have to go, calling their uncle, if you make it their uncle the trustee, every time they need something for, I need college tuition, or I have this trip I need to do for school. They don't have to always be asking permission from a third party. If you trust them to manage their own trust, you can make them trustee of their own trust, which is what I'm doing. Remember, my age of distribution is never, but I'm making my kids trustees of their own trust, because if they ever need funds for health, education, maintenance support, they can simply write a check to themselves and not have to make a case, with a third party. So that's something only you can decide, because you know your kids. And if you make them trustee of their own trust, who would you allow them to direct any trust assets to? Because if they are doing well, for example, they may want to direct some of their trust assets to someone they care about. What is the limit? For a lot of parents, they want to keep it in the bloodlines. They can only share their trust with their siblings or their children, no spouses. For some families, they say, okay, bloodline and charity, so they can, give part of their inheritance to their church, to their siblings and the children, still no spouses. That is called a limited power of appointment, and the extent of that limit is your decision, because this is you dictate that. Okay, so these are some key decisions that you need to think about. Don't like go knocking at an attorney's door or sign up in a platform before you have time to mull this over. Then there are key successor roles. When you're not around, these people are stepping in to do your job. Who do you trust to be your healthcare proxy, your power of attorney, guardian if you have minor children? Executors are for a will. If you do a trust, you need a trustee, a successor trustee. You don't need a full will. You just need something called a pour over will. And it's just a safety net that tells the judge, hey, if there's any asset I forget to transfer into my trust, this tells you that I want to pour everything over into the trust. So you still need an executor for the pour over will. So these are just when you sign up with me, I give you a list of key decisions to mull over, to think about, to discuss with your family. Great. Now, the second step, if you remember, was finding a team to build that house. So for a trust, it's deciding on the estate planning online platforms. So let me just give you a quick overview, okay? Because there's a myriad of online planning platforms options out there, but you can think of them in three categories, okay? The first is general legal platforms. These are platforms like Law Depot, LegalZoom. They're general because people go to these platforms to create rental leases, purchase and sale contracts, and they decide to add estate planning documents as well. I would advise you to stay away from these general legal platforms because, I tried one of them, and even the customer support, I had to go down a long tree before I found a customer support person for my estate planning questions. The second category are dedicated estate planning platforms. These platforms were created from the get-go to only specialize in estate planning, like Trust and Will, willmaker.com. I find these much more reliable because the customer service, everybody in that company is dedicated to help me with my estate planning needs. These are usually for mainstream customers, for mainstream families. Now,
Excuse me,
yes.
your head is blocking the
Okay, let me move this to this
because
side. We're
because
gonna,
that's is that a website, right? Can you move the other way?
okay. All right.
The
So
other way. What?
thank you
Law
for,
Depot? I can't see.
oh, okay, okay. How about now?
Lawdepot.com. And what's the second one?
Rocket Lawyer and LegalZoom.com. Here, there are many of them. Here are just three examples. Okay, now I'm talking about the third category, so I'm going to move to this side. Can you see the third category now? The third category of
Yes.
estate planning platforms, thank you very much for speaking up, okay? I appreciate it. The third category of estate planning platforms are what is called invitation only by advisors. Now, these platforms were created for advisors, financial planners, and their clients. So they tend to be more sophisticated platforms because the families who are working with financial advisors and planners tend to have more complex, asset portfolio, and more nuanced family situations. And some examples of these platforms are Wealth.com, Vanilla, and Estately. Wealth.com is the platform that I've partnered with. So these are the three categories of online planning platforms if you are, out there researching them. So step number 2, whichever one you choose, you want to be sure that it has these features. I'm going to move back here. Yes. You have all these features. I'm just going to go through them quickly. I will be sending you a replay of this webinar, so don't feel like you have to take notes on these features. But for sure, the first one is that it's easy to use. It's it's user friendly, and at the same time, it's flexible and powerful because, like I said, we want to create a trust that gives us those protections, not just, any trust. You want to make sure it's attorney drafted, not AI, not AI, not uh, by computers. You want to make sure that there an attorney team behind the platform that created the documents, and that it's but tailored to each state because every state have different requirements. Support is so important, not just live chat, but you want to make sure that it offers phone support because if you're probably not well versed in estate planning concepts, if this is your first trust, so you want to make sure you can actually talk to someone. The summary reports and is very important because I'll show you later. When you have a 30-page legal trust to go over every year, it's probably tough going. But if you have a summary, a tabular summary of the key decisions you've made, it's easier to review them annually. And it is important to review your plan annually. Because an estate plan is not a one and done. Your families change, tax rules change, so of course your estate plans will change. And of course, security, you have some confidential information there. You want to make sure the security is top notch. So, for example, here with wealth.com, when I say that it's user friendly, the platform should be question driven. This example, for example, at what age should each descendant trust end? It's a matter of choosing the age and choosing the fraction that you want to distribute the first time around, and then what age should the rest be distributed? Or, as I mentioned in my case, you can choose that it does not get distributed until the descendants pass away. Here, examples of summary reports. So instead of having to go through 30 pages of your trust, you can quickly just scroll down here and see what your key decisions are. So you can make sure, hey, are those trustees still healthy? Because I had an instance where one trustee moves out of the country, in which case I would have to update the trust. But this just allows you a quick way to review your trust, which means it encourages you to review it because hard things don't get done. Easier things get done. Now, in the third step, we're on this fourth step to creating your trust. Signature witnesses notary is so important. And you want a platform that can give you a quick summary of what documents need to be signed, witnessed, and notarized. This is so important because when a DIY trust fails, it's almost always because it wasn't signed, witnessed, or notarized properly. So you want to take this seriously. In fact, I recommend my clients before they go to the bank to get it notarized. By the way, banks offer notarization for free, so that's what I usually recommend. Before you go to the notary public at the bank, use these stickies, even if you don't have them, use some yellow stickies to post to tag all the pages on all your documents that need to be signed, witnessed, or notarized. You don't want to be at the notary public's office and flipping through your pages. That's how pages get missed. Okay, but this warrants to be its own step because it's so important getting it signed. An unsigned or an unnotarized document, if it needs notarization, is an invalid document. The fourth step is funding the trust. And I alluded to this. It's basically transferring your assets out of your name into the trust. And this is not referring to all your assets. These are just probate assets that can be probated otherwise. So your IRAs, your life insurance, you should not be transferring those into your living trust. Otherwise, you'll trigger some severe tax consequences. What you want to put in your trust are your houses, if you have rental properties, or if you have a business, partnership interests. Again, you'll be provided a checklist on what to put inside your trust and what not to put inside your trust. This is the funding process. But don't worry about it because you cannot transfer anything into your trust until it's completely finalized and notarized. So that should be your first focus. All right. So, let's summarize what we've gone through, okay? We talked about the 3 threats: probate, wealth erosion, family fracture. Then we talked about how a living trust addresses those threats by transferring titles, by staggering distributions. And then we talked about the 4 steps of creating a trust. Some of the decisions you want to think about, your children, your spouses, and we even looked at some examples of some wealth.com screens. So congratulations, you now know a lot more about estate planning than 90% of your friends, is my guess. But here's the thing though. Are you here just to get more information, or is your goal to get your estate plan finally done? You have traditionally 2 choices. First is DIY, do it yourself completely. That's the definition. You're doing it alone. You'll be spending time researching on best options, weighing trade-offs. And after all that, you're still a little bit uncertain because it may be your first time and you're making your best guess. This is the DIY option that I don't recommend because it may be cheap, but it costs you sleep. Okay, the second option is there is online courses. There are online courses out there on the web that's offering you to teach you step by step how to DIY your plan. It's easy to start, but it's also easy to stall because there's nobody really pushing you. And with these online courses, you still have to sign up on an estate planning platform, which costs additional expense. If the online course provides its own estate planning platform, it's usually very generic. The ones I've seen would recommend some platforms to sign, which is not free. It lacks one-on-one support. You get a lot of knowledge, but when it comes down to actually doing it and you have questions, you don't have a guide. So the data shows that with online courses, and it's not just me saying it, but the completion rate is quite low. I want to present to you a third option, which is working with an estate plan partner. Okay. And you will be able to complete your estate planning documents in 3 one-on-one advisor meetings. That's our program, because we have a one-on-one guide working you through that entire process. Let's drill down more into what it means to work with an estate plan partner. It's an all-inclusive one-stop program with 3 different components. First is you are working with a certified estate planner, and all the scripts, worksheets, shortcuts that she has to help you get to the finish line, all the resources will be available to you. The second portion is the wealth.com platform. Feel free to go to wealth.com and research this online platform. You will not be able to sign up on your own because, as I said, it's invitation only, but you can get an idea about the team backing up this platform. And then the third component is that you'll be able to create your complete estate plan. Okay, let's unpack each one of these components further. So working with an estate planning partner means one-on-one support. We'll have 3 one-on-one meetings, the onboarding, a review, and then a trust funding training. And checklists, shortcuts, resources will be made available to you. The wealth.com platform is, again, invitation only, and the drafting is all by attorneys. You have unlimited plan edits because a lot of families never feel ready. They say, I don't have all my decisions, made yet. That's the wonderful thing about an online planning platform. You do your first draft, you mull it over, and the only way you can really think about your decisions is to first take a stab at it. Just take a stab at the first round of decisions. You can mull it over, talk it over with your spouses, with friends, with your kids, and you can always go back to the platform and edit, make changes, and reprint those documents. Just don't get them signed or notarized yet until you feel, quite good about them. You have, as I said, support, not just live chat, but phone and email support. And you get the summary reports that I showed you, just a few sample of. The third part, the complete estate plan, you get a revocable living trust, a pour over will, which is a safety net for your living trust, a healthcare proxy, and the power of attorney. These are the 4 core documents of an estate plan that you will be making with me. The bottom line is that you get to make real progress. For example, just after the first one-on-one session with me, you get a draft of your living trust. Okay? That is quick progress because the other documents are a lot simpler. The living trust is the most complicated, and you leave the first session with a draft of it. Why not a completed living trust? Because an estate plan is like Texas barbecue. This is what I mean, okay? Because I was just in Texas and had the pleasure of enjoying the best Texas barbecue ever. So it takes just moments to marinate, to rub your Texas, barbecue meats. And then it takes, I learned, like 18 hours, sometimes 2 days to really let all that marinade seep in to turn it into that legendary Texas barbecue that I hope you have the fortune to try. Estate planning is like that. Actually drafting and making those decisions and choosing an age and checking off yes, no, and answering those questions take like less than an hour. But what you want to do after that is to really mull it over, talk it over with your spouses, with your relatives. Hey, how did you handle this situation? Talk it over with your wife. Do you think, our child is ready to be trustee at this age? That is what takes more time, the ruminating about the decisions that you make. With a DIY or online course, you're sure to get a lot of information, but will you actually make real progress towards the finish line? Let's talk about costs. So for sure, don't just do nothing because the cost of probate is very steep. Not just the cost, but the emotional drain of it, the stress and the family fracture that you often see when estates go to probate. That is something you want to avoid. You can go with an attorney. I'm sure you've done a lot of research. They can charge $3,000 to $5,000 if you are looking for the whole plan, not just the living trust, but the pour over will and the healthcare proxy and so on. Do it yourself. You may think is free, but it's not because the platforms that you'll be using to draft the documents have a cost to them. LegalZoom, for example, charges $500 for a couple. Trust and Will charges almost $600, and you only have 30 days to edit your documents. You can extend it for an additional cost. So when you look at these options, what do you think would be reasonable for a program to cost? A program that provides you one-on-one support, one-on-one expert support with a certified estate planner, a program that includes the estate planning platform, not just one for mainstream families, but one that's, top-notch. and includes all the estate plan documents you need. What do you think would be reasonable? This is audience participation time. Someone give me a number? No suggestions. Well, the title of this webinar was, how to create your estate plan under $1,000. So I definitely can't charge more than $1,000. The cost for the program, the all-inclusive program, is $795 for a couple and $595 if you're just a single or an individual or a widow. That's $695. But I'm going to do better because you're all my YouTube viewers and subscribers. So I am taking $200 off if you take action by next Monday, midnight. Now, why the deadline, right? I get asked that more often than why the discount. Okay, why the deadline? And this is my honest answer. Why not? Why not take action today, soon, by Monday? Because my guess is, and I've worked with numerous clients who know this, my guess is you have been doing a lot of thinking about estate planning. You've been researching different options. You've been worried every time you get on that plane to make a big trip. And now you've spent another hour, you've invested another precious hour with me in this webinar. Surely it's not just to get more information. It's because you really, finally, you want to make this happen. So why not take action? And when I think about the clients I've worked with, here, I got this email very recently from a client, and this was June 25th. So less than a month ago, I got this email. And when I first read this first sentence, I started working with her in December. And then I got this email. My husband, Ray, passed away, and I stopped breathing because that's always what you're afraid of. Somebody passing away before the plan is done. So I stopped breathing until I read this sentence here. Our will and trust was notarized. Everything was signed and notarized. Only then could I breathe. When I think about how close this person came to a family tragedy without an estate plan, or this another email from this other person. She said, I completed my estate planning documents and I transferred my assets. And she said, thank you for lighting the fire under me. Here, thank you for lighting a fire under me. When I read emails like this, I realize it is my job. It is my job to push you, to nudge you, to encourage you to move from information overload to taking action. And I'm doing my part. Taking off $200, now it costs even less than these online platforms like Trust and Will that provides no human guidance at all. So now that's $595 for a couple and $495 for a single person. When you sign up, you get these bonuses, okay? The first bonus is a 53 plus page checklist for estate planning, because I get families asking me all the time, how do I know I'm picking the right trustee? How do I know I'm picking a good healthcare proxy or power of attorney? So I put all that in this book. Anything checklist, for example, we talked about what assets should I put inside a trust, what assets should stay out of the trust. That's just checklists that you can find in this book. That's your first bonus. The second bonus is lifetime unlimited edits. Let me tell you what happened with my trust, okay? 10 years ago, I created my living trust with an attorney because there was no other resources that were as available as today. So I created my trust with an attorney, and I even created a video outlining that process. It's in my channel if you want to watch it. I paid $5,000 to create this trust with an attorney. And then a few years later, one of my trustee moved abroad. So I had to get a replacement trustee. And I went to the attorney to make that change. And he said that the smallest, the minimum, the smallest change, it would cost $500. This was a tiny change. It's just a name change. I was so tempted to get my white out and just white out the original document itself. Can you imagine having a platform that allows you to go in anytime and make edits without having to pay an attorney, fees every time? That's the second bonus, lifetime unlimited edits. The third bonus, the third bonus, the third bonus will blow you away. Okay. So 2/3 of Americans have not done their estate plan, which is why I went into this as my second career, because that's a lot of people who are going to end up in probate. You are in a very special place where you actually are going to take action and get your estate plan done. After your estate plan done, I'd like you to share my passion for estate planning with your friends. That's bonus number 3. I am giving you a complimentary wealth.com account. And all the resources, scripts, templates, the bonuses, and the lifetime unlimited edits, when you have your plan done, you will be able to give this account to a friend, a neighbor, a parent. Some of your parents have not done a plan, which is not in your favor. You can take this complimentary wealth.com account and give this gift to someone, this gift of having the peace of mind that you're not leaving a mess for your family, because probate never hits you. You will never experience probate. It's your children, your family, it's the loved ones you leave behind that has to deal with probate. So that's my bonus number 3. But you will only get this bonus after you complete your plan. Okay? All right. So where you can sign up is estateplanpartner.com. And I've got the wrong dates in here, so I will honor it. Sunday, February 18th. As long as you sign up by this date, you will get the $200 off and the 3 bonuses. When you go to this website, you will see this screen, and you will choose whether you're doing a single plan or a couples plan. After you make that choice, you will get a payment screen, and it's very important that you put in the promo code so you get the $200 discount. The promo code is TRUST200. And once you make the payment, you will get a page to make your first one-on-one appointment with me. And by the end of this one-on-one appointment, you will have a draft of your living trust. Whether it's 30 minutes from now or 30 days from when you sign up, even if I've invested, 2 hours with you to create your draft living trust, whether it's 30 minutes from now or 30 days from now, if you don't feel that this is what you need, just email me, and it's 100% money back guarantee. I want you to feel totally comfortable being on the inside, like really checking out the platform, meeting with me, being on the inside and checking out everything before you decide if this is what you want. So I have no problem offering you this 100% money back guarantee. Questions?